litigation is an expensive process, and clients are often very concerned about how the case is going to be funded and whether it's going to cost them anything.
Sometimes there can be what appear to be unrelated things in their medical history that might be important.
The burden is on the individual client, the claimant, to prove their case, and so the burden is entirely on us to get that evidence that we need.
A huge proportion settle without going anywhere near a court.
We operate mostly on no-win, no-fee agreements, and it does give the client that benefit of knowing that they can investigate the case with absolutely no financial risk to them. Hello, and welcome to today's episode of Medical Negligence Matters. Today we're going to be talking about the process and understanding the process of bringing a medical negligence claim. And joining me today is my good friend and colleague, Corrina Mottram. Hi, Corrina. Thanks for being here.
Thanks for asking me.
So the first thing let's start with stage one. What do we do? When a client first comes to us, the initial step, I suppose, is understanding exactly what it is that's happened to them. How do we do that?
Well, we've got a number of ways that people can approach us. There's a dedicated phone number, there's an email address they can use, find us online, make contact, and we have some wonderful nurse advisors who work with us who will speak to the people who are making the inquiries, find out as much as possible. And
there's no charge for that, is there?
No, absolutely free. And they will take as long as necessary to make sure that they've properly understood all of the issues that our potential client wants to explore. They will then bring it to a meeting with all of the lawyers at which we'll discuss all of those issues and try to work out whether or not we think it's something we might be able to help with.
Exactly. And I think that's the thing that's quite important is that we get the details that the client can tell us about what happened, which aren't necessarily complete, but as much as they know, can be considered by all of the lawyers. And I think that's quite an important process because, of course, there's a vast amount of expertise amongst the lawyers who work with us. And most things have been seen before. So it's not often that we get something that comes to us that's so out of the ordinary that we don't know anything about it.
No, absolutely. I can't think. I mean, there's always some unusual twist that comes up, but usually the broader context of a particular type of injury or a particular type of underlying condition, illness, disease is something that many of us, if not all of us around the table, will be familiar with in some way or another.
Exactly. And of course, each case is unique, isn't it? I mean, it's very important that there's no individual's experience is exactly the same as somebody else's. So it's always important to take into account the circumstances of that individual. And so that initial consultation process is entirely free. And it enables us, I guess, to give an answer to the client as to whether or not there's something that's worth looking at and worth investigating. And the next step after that is funding, isn't it? Because, of course, litigation is an expensive process. And clients are often very concerned about how the case is going to be funded and whether it's going to cost them anything.
Yeah, we've got a number of options that we can use. So there is still legal aid available, but it's available in such narrow circumstances. It's really only available to children who've been brain damaged in the first few weeks of life. And so it's a very small, very important, but very small number of cases where that is even a possibility. Some people have some form of legal expenses insurance, or they may have some other type of
trade union
membership,
that sort of thing, yeah.
Which may offer them cover that may well be appropriate. Legal expenses insurance often have quite tight limits on what can be spent, and these claims can be very expensive to investigate, and so those options aren't always appropriate. The third option, and the one that we use almost exclusively, is the conditional fee agreement, which is a real no-win, no-fee, where the client isn't at any kind of financial risk during the investigation process and should the claim not succeed. But it gives them that security and enables us to do everything that needs to be done with the benefit of an insurance policy that sits alongside it.
Exactly. So the client knows that funding is in place that's going to cover them for the entirety of the claim. And actually, you reminded me, talking about legal expenses insurance, to say a lot of people do have that sort of cover under their house insurance or car insurance policies. But it does, as you've mentioned, have some limits, not only in terms of the extent of the indemnity, but also sometimes in restrictions on the lawyer that you can use. And sometimes your insurance company will insist on instructing a certain type of lawyer or a particular lawyer, which isn't always in
They're
the
not
individuals.
always specialists.
Exactly. And so, as you say, we operate mostly on no-win, no-fee agreements, and it does give the client that benefit of knowing that they can investigate the case with absolutely no financial risk to them. And we get that funding in place right away. So it's there, it's dealt with, it's out of the way, and it's something that they don't need to worry about again. And then what's the next step?
We then need to start investigating proper. So at that point, it will be allocated to a lawyer. So and whichever lawyer it's allocated to will then own that case, as it were, from start to finish. And you won't find yourself being farmed out to someone more junior to do certain things. There won't be a whole raft of people working on your claim. It will be one person.
That's a good point, isn't it? Because it enables that individual lawyer to form a proper relationship and understanding of the client and their circumstances, their background, their family.
And I think with people who've been through these sorts of experiences where they feel they've already been let down by the medical profession, I think it's really important that they feel they can build up a relationship of trust with another professional who they're relying on to help them get to the bottom of what went on before.
And how do you go about actually gathering the evidence?
Well, first, most importantly, is meeting with the client, getting their story. But then the absolutely crucial step is getting the medical records. And we do that as soon as we've met with the client so that we've got an understanding of what they think has happened, which isn't always exactly what we end up focusing on, depending on what comes out of the records. But it's really helpful to have that understanding from them, their perspective of what's gone on. We get the records. We spend quite a lot of time looking at those records, going through them in as much detail as is necessary. We will look at any other evidence they might have, whether it's photos, videos, any other documents that may be relevant.
And on the medical records, it's not necessarily just the records that relate to the specific incident that the client comes to us about, is it? I mean, it's very important that the medical records that are obtained are the entire history. And some clients can maybe be a bit uncomfortable about that, but it is important.
It really is. We need to be able to be sure that we've understood the context of the particular issue that they've come to us about, because even particularly in relation to a long-standing condition, it's very important that we know what the background is and how it started and how it's affected someone in the past, to be able to understand what may have gone wrong now. And sometimes there can be what appear to be unrelated things in their medical history that might be important, either as a cue that should have led the medical professional to say, we need to look at something else here because you've got this in your background and that could be relevant, or because they've simply, it is a continuation of something and someone's not appreciated that.
So it's not something that a client should be concerned about, that their whole medical history is brought into question, but it is something that actually can benefit the cases, because there may be things in that background that is useful in establishing the claim.
No, absolutely.
And also countering any arguments that come from a defendant about what would have happened in any event. Isn't it? So once we've got all those medical records, what then? We
then get a medical expert involved. Sometimes we'll need several as the case proceeds, but we will start with one. Usually it will be someone of the discipline that we are criticising. So say it's a GP who's failed to make a referral for a particular problem that's been ongoing for a while. We'll get a GP expert to look at those records in particular, but to consider the whole history and advise whether or not a referral should have been made more quickly, a different referral should have been made, some other action taken. Once we get that report, it will either help us in saying, yes, there is a claim that should be pursued. There have been failings on the part of the particular GP or other medical expert, or no, in fact, although it's not worked out the way anyone would have hoped, the treatment that was provided was reasonable, it was acceptable. Sometimes they will say that further reports are needed, that input from another discipline is necessary to round out the picture.
Yeah, you're right. I mean, because there's not very many cases where you just have one expert, is there really? Because we start off because there's various elements of the claim that have to be established, and quite often those each need their own independent expert specialty to look at. So a breach of duty, as you say, might be on the part of a GP. But for example, if it's a delay in referring for an investigation of cancer, then if the GP is critical, then we'll need a report from an oncologist or a specialist in the cancer to tell us, well, what would have happened if the referral had occurred earlier. I mean, so there's often a number of reports that have to be obtained.
No, that's absolutely right. And sometimes clients can find that quite frustrating, or they don't necessarily understand why we're getting yet another report. And obviously it's for us to explain that to them. And usually once you explain that these are all parts of the jigsaw puzzle, and it's really important to get all of those pieces in place to make sure that we're presenting the claim in exactly the right way.
Yeah, I mean, the expert evidence is really the crucial evidence, isn't it, in any medical negligence case, because ultimately a claim stands or falls on the strength of that evidence. And so the selection of those experts is really important. And how do we go about that? I mean, we have a list.
Yeah, we've got a database. And as you were saying a few minutes ago, we've got a huge wealth of experience in the office of people who've dealt with so many different claims over so many years. And we are constantly in and out to each other. Who would you recommend for this? Or have you got a good one of these in terms of experts?
Because of course, we need good experts who are still practicing in the relevant fields, who have current knowledge, and who are suitably experts, so it's at least consultant level. Yeah. But we also need people who are going to be objective, don't they? But we don't necessarily want an expert just to tell us what they think we want to hear and then change their mind somewhere later on down the line, because that can be disastrous. We need somebody who can give us a balanced view and tell us also where the possible weaknesses in the case might be. It's not all one way.
I think that's absolutely right. And I think a lot of clients also do have some concern that the experts we instruct might just kind of circle the wagons and they'll protect their own and they won't criticise the clinician that we are thinking of criticising. And I think it's really important that we can reassure them that the experts we instruct are those who have a track record of being able to say and being willing to say, no, this treatment was not okay. There were these errors, things that weren't done that should have been done, or things that were done that shouldn't have been. And I think it's really important that we're able to give that reassurance that we have worked with these people, we have seen their reports before, and we know that they, in appropriate circumstances, will criticise and will do so without kind of fear of any consequences for that.
And also, we will make sure that they're entirely independent of any of the treating doctors, don't we? And one of the things that we will be very careful of is to make sure that when we're approaching an expert for a report, that we tell them where the incident happened, who was involved in it, so that they have an opportunity to say if they have any links which would potentially give them a conflict of interest. And it's very important. And I think that so our clients can be reassured that the people that we're going to are true experts in their field and that they don't have any interest that's contrary, to their own. And that they're going to give a good and honest opinion. So they're not a hired gun. They're not somebody that's just going to say what we want them to say.
No, and that really is unhelpful because, as you said a minute ago, sometimes what that means is that they say, oh, yes, at the outset. And then a year or more down the line, they say, oh, well, actually, it's not quite as black and white as I suggested it was. And then you've just wasted all of that time for the client, possibly taken them down a road that they should never have been brought down, and it just adds to the dissatisfaction, the distress that they've experienced.
Yeah, it's the most critical, and we will spend a lot of time making sure that we've got that evidence right, won't we? Because it's the burden is on the individual client, the claimant, to prove their case, and so the burden is entirely on us to get that evidence that we need to make the case stand up. And once we've got all our evidence there, what's next?
We then put the claim to the defendant, whether that's a hospital trust on behalf of doctors or other clinicians working for that trust, whether it's a GP or ambulance service, some other branch, some other organisation within the healthcare sector. We'll put the claim to them.
And we have to do a formal letter of claim.
We do.
There is a certain procedure for that.
And it's quite detailed, and we have to set out in some detail exactly what it is we say they have done wrong, which is why it's so important to get that independent expert evidence first. Because in other areas of law, you can just send a letter of claim out pretty much as soon as you've met the client, particularly if it's a road traffic accident or something. You say, well, this is what they did wrong. They went through a red light or whatever it might be. We're not medical professionals. We can't say with any authority what a particular doctor did wrong. And so it's really important that the allegations we put in that letter of claim are backed up, are based on the opinion of an independent expert who does have the appropriate qualifications, does have the relevant expertise, and so that claim is as solid as possible and is put forward properly and correctly, and we're not making allegations that we can't really back
be
up.
substantiated.
Yeah, I think
absolutely.
That's the wrong thing to do.
And it has to have sufficient detail in it to enable the defendant to properly investigate, to go off and get their own witness statements, to get their own independent expert views themselves.
Yeah.
And the idea is that it then gives them an opportunity to give a detailed response to that before anybody considers going anywhere near a courtroom. And that can be a useful process, isn't it? Because we then do get an idea of what they say about what happened.
Absolutely, because their response can be one of a number of things. They might admit everything and say, yes, we hold our hands up. We did the failings that you've identified are correct. We accept them, and we accept the harm that you say has followed. They might deny everything and say, no, terribly sorry, but none of this is our fault. It's an awful thing that's happened to you, but not our problem. Or there might be some sort of halfway house where they may admit that there were some mistakes made, but deny that they caused any harm that wouldn't have happened otherwise. They might admit a very small amount of harm, whereas in fact you're claiming that something has been a much bigger problem for the client than they're accepting. And in every scenario, apart from the complete admission, we will then want to get our experts to look at that and comment on it. It's really useful to have that detailed response, even if it is a denial, because it helps us to make sure that we have addressed all of the points properly and as fully as possible.
And it also narrows the issues, I guess, isn't it? Because quite often when you start out, you think there's all sorts of areas that you're looking at and all sorts of possible questions. But ultimately, most cases really come down to one or two things. And the key thing, the most efficient way of dealing with the case and the most effective way is to try and identify those really critical issues as early as you can.
Yeah.
Right? And so while the defendants are considering the letter of claim and preparing their response, we don't just sit on our hands, do we? I mean,
No.
there is other work we will do. And I think the most crucial thing is starting to think about the extent of the injury, isn't it, really? And identifying, well, first of all, the physical or psychological injury that's been suffered, but also the financial consequences of that.
And they can be, very significant. So we will, if additional medical evidence is needed about the physical and psychological injuries, as you say, we will be getting that during that period. We'll also be gathering information about lost earnings, about care costs. So if spouses, partners, parents, children, friends have been coming in to do things for the injured person that they would ordinarily do for themselves, we can claim back for that time. We can. It's notional, but obviously in a substantial claim, it can add up to a great deal. Even if it's a small amount, I think it's right that it's recognised and it's right that it's compensated.
Yes, and we can take that time to actually gather the evidence that we need from family members or from employers or this sort of thing in order to be able to work out exactly what the claim entails in terms of the pure financial side of things. And then once we've got the defendant's response, well, as you say, if it's a full admission, then we could hopefully move fairly quickly into negotiating. And this is true, isn't it? Not every case goes to trial. In fact, the vast majority of cases settle long before any potential trial.
Yes, I think it's a tiny percentage. It's 2 or 3% of cases actually end up at trial. A huge proportion settle without going anywhere near a court, and another very large proportion will settle even if court proceedings are commenced. That doesn't mean you're going to go to trial automatically. You can still settle at any point along the process, from the beginning proceedings to walking in the door of court on the first day of trial.
I think, clients often are very wary or worried about the prospect of actually going to court. And although I always say to clients, you have to be prepared to go that far if you need to. But the reality is the vast majority, 96% or more, probably more than that, will settle without going to trial. And how about the sort of the settlement process these days? I mean, how does that work?
There are a variety of ways that we can get there. So we will have got the evidence that we were talking about a minute ago whilst the defendant is considering the claim. We will have got the medical reports, we'll have gathered all of the financial information. So we will have formed a view on the overall value of the claim. And we will have advised our client, had any discussions with them about anything they don't understand, anything they think has been missed, or any issues that we think need to be dealt with slightly differently. We will usually, if there is an admission, we would often ask the other side to make an offer. We will send the relevant information to them. So we'll send those medical reports, a calculation of those financial losses to them, and invite them to make an offer. And if they do so, we'll advise our client whether we think it's a very good offer, which is rare in the first instance, but occasionally the first offer is a good one, or whether it's something that is good enough that we can negotiate and hopefully get to the right point, or not.
Yes, there's various ways of getting to the end result, isn't there? And I mean, maybe that's something that we'll have to deal with in more detail next time. But in the meantime, thanks very much, Corrina.
Thank you.